You believe your doctor was careless and caused you significant harm and injury. You go to try and find the best attorney you can to take on your case, and you believe you have a great case. Would you like to know why some attorneys are not going to accept your case? Would you like to know what four things an attorney is going to look for when deciding whether to take on your case? Come join me for a walk around the lake as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you suffered significant harm and injury, you believe, because your doctor was careless. And now, you believe in your heart of hearts that you have a valid case. Not just that you have a valid case, but you have a great case. So now you are trying to find the best attorney you can. You make an appointment with the best attorney you can find, and now you spend an hour in his office telling him everything that happened. And you walk out of his office thinking, oh my God, he's going to take my case. How could he not take my case? I have a fantastic case. Let me share with you the 4 things an attorney needs to look at when evaluating your case to decide whether or not to actually accept your medical malpractice case. Okay, number 1, your attorney needs to find out whether there's liability, whether in fact the doctor departed from the standard of care, whether he was negligent. Now, what does that mean? It means that your attorney will have to get all of your medical records and have them reviewed by a medical expert. A medical expert going through all of those records are going to have to determine whether or not the doctor or the doctors or hospital staff violated from the basic standards of medical care, whether or not they were careless. Now, is that it? No, that's not it. That's only the first element that an attorney is going to look at to see whether or not you have a good case. Now, notice I didn't say a great case, I said a good case. And there's a distinction. So the first thing we look for is to see if the doctor and the hospital staff that treated you did everything they were supposed to do. If the answer is no, and there are certain things that they did wrong, then we have to ask the question, what harm did you suffer as a result of the fact that they did something wrong? If, for example, you suffered some bruising, some minor temporary inconvenience, some temporary injury, in that instance, it is highly unlikely that you're going to find a really good, experienced medical malpractice attorney to take on your case. Now, what is that called? In law, we call that causation. There has to be a connection, a link, between the doctor's wrongdoing and the injury that you suffer. There has to be that bridge, that connection. If there is no connection between the wrongdoing and your injury, guess what? You have no case. We are required by law to establish that you are slightly more likely right than wrong, that what you are claiming is true. And number 1, that the doctor was careless, and that his carelessness was a cause of your injury. It doesn't have to be the cause, because there could be multiple causes. It only has to be a cause. Now, what's the third element that an attorney is going to look at to see whether or not you have a good case? The third element is what we call damages. What is the value of your injury? What type of injury did you suffer? Do you have permanent, ongoing, long-lasting, disabling injuries? Are you unable to work? Are you going to need surgery into the future? Do you need ongoing medical care and treatment? Will you need physical medicine, physical rehabilitation? And how is this going to affect you on an everyday basis? How are these injuries going to affect you going forward? Importantly, how are these injuries going to affect you for the rest of your life? If you have significant, long-lasting, long-term injuries and disabilities, now this is going to interest most attorneys that you talk to. Why? Because now they will recognize that no matter what has occurred, they are now dealing with someone who suffered very, very substantial injuries. The key question is whether or not the medical expert who is reviewing your record can validate and support the fact that your doctor or hospital staff was careless. And then whether or not he can validate whether that carelessness was a cause of your injury. There are many instances where a patient's injury is not related to whatever was done wrong. That is a problem. It's a significant problem, and that will prevent many people from going forward and bringing a case. Now, I said that there were 4 different things. 4? Yeah, here we go. 4 different things that an attorney is going to look for to see whether or not he's going to take you on as a client. And the fourth thing that I think most experienced medical malpractice attorneys in New York would agree. What kind of person are you? Are you a vindictive person? Are you nasty? Are you obnoxious? Or are you nice? Are you pleasant? Are you easy to get along with? Do you recognize that this is a problem, but you're willing to push forward and to try and do the best you can in life with the disabling injuries that you have? Or is this case going to consume you 24 hours a day for the next 2 or 3 years if you go forward with litigation with this attorney? Why is that important? It's important because the attorney is going to have to live with you and your case over the next 2 to 3 years. And I will tell you from experience that if the client does not come across as personable, as lovely, as pleasant, as a nice person, then that's going to be a problem. Why? I am already anticipating what a jury is thinking as now you are in front of a jury 2 or 3 years down the road. And now you're in front of 6 strangers of the community. They are now judging you and judging whether you are slightly more likely right than wrong than what you are claiming is true. They are judging your experts, but importantly, they are judging you and your credibility. If you come across as being vindictive, if you come across as being nasty, as condescending, now the jury will get in their minds that you may not be worthy of a verdict in your favor. In that instance, it doesn't matter what happened to you. It doesn't matter whether the doctor did something wrong and violated the standard of care. It doesn't matter whether his carelessness was a cause of your injury. Because if you don't come across personable, if you don't come across as being reasonable, if you don't come across as being a true, good, honest human being, you, my friend, are going to have a significant problem when your case ultimately goes to trial. And now you are trying to put forth your best foot and your best case to 6 members of the community who don't know you. They don't know what you've been through. They don't know the injuries. They don't know the disabilities. They don't know the pain and the suffering that you endured. And here you are now trying to explain to them. And if you are nasty and obnoxious and not pleasant, guess what? That makes a huge impression on a jury. Now, everybody's different. Everybody has different pain levels. Everybody goes through things differently and reacts to pain differently, and that's totally understandable. However, there's a big difference between somebody who is nasty and obnoxious and somebody who is trying to do the best they can for themselves and for their family despite, or I should say in spite of, their disabilities. So why do I share these 4 things, these 4 criteria that most experienced trial lawyers are going to look for when deciding whether or not to accept you as a client? I do it because most people get in their minds before they ever pick up the phone to call an attorney that they have a great case. They may not know exactly what was done or exactly what was done wrong. They may not know the precise injuries that were caused by something that was done wrong, but they have in their mind that they know that this person did something wrong, they had to have done something wrong because they went into the hospital fine and now they came out paralyzed or they have some other disabling injury. However, that may not always be true. So it's critically important for any attorney that you go to look to see whether or not you have all 3 elements necessary to make out what we call a prima facie case, which really says that you have a good case, you have a valid case, and an expert who can support that. And importantly, we look to see what type of person you are. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.